I won a $5 million judgment against the MyPillowGuy. Now I'm taking him to the Supreme Court. Earlier this summer, the U.S. Court of Appeals for the Eighth Circuit overturned my $5 million judgment against MyPillow CEO Mike Lindell for having won a challenge to prove that his claims of election fraud in 2020 were nonsense. This decision is not only bad for me, but bad for America. It upends the century-old Federal Arbitration Act, and it diverts resources from legitimate investigations for improving our voting system to crazy conspiracies from wealthy plutocrats. I'm hoping the Supreme Court will reconsider this harmful ruling. Yeah, don't hold your breath with this. I'm hoping the Supreme Court will reconsider this harmful ruling. Yeah, I think you're gonna stay hoping. Okay, don't hold your breath with this Supreme Court makeup. Okay, they've shown that they're not principled whatsoever. Here is some background. In the summer of 2021, Lindell announced that he was going to hold a cyber symposium in Sioux Falls, South Dakota, to release data that proved that U.S. voting machines were hacked by China. He said he would pay $5 million to anyone who could, quote, prove Mike wrong. At the insistence of friends, I got myself invited, but told them that examining this kind of data would take weeks or months using specialized tools. But I was wrong. It took me 3 hours to prove that the data was completely bogus. I wrote up a report on my findings, submitted it to Lindell's symposium director, and waited. After a month with no response, I approached lawyers, and Brian Glasser and Casey Joshi at Bailey Glasser agreed to take my case. We went to arbitration as Lindell's contest rules required. We prepared our case, held depositions, went to the hearing in front of 3 experienced arbiters, and after a year and a half, in April 2023, we got a unanimous decision. I had proved Mike wrong. He owed me $5 million. Lindell took the arbitration ruling to federal court in October 2023. Each party submitted a short brief to the court, and then lawyers from both parties each got about half an hour to present their arguments to Judge John R. Thunheim. Months later, in February 2024, he ruled that his hands were tied. In his decision, he questioned whether he would have ruled the same way as the arbiters, but confirmed that he had no ability to overrule their binding decision. That's how the Federal Arbitration Act has worked since it was enacted in 1925. Basically, he's saying that, like, when you appeal, the guy beats Mike. Mike loses in the arbitration agreement. Okay, so then Mike says, I don't want to pay the $5 million. I'm going to take this to actual real federal court. The court then then the judge basically says, look, it's not my job to argue whether the arbiters in the arbitration case ruled correctly, right? I just have to go with their ruling. If they ruled that you guys agreed to arbitration, and that if you go to arbitration and you lose, you have to run with that binding. And so he says, regardless of how I would have ruled as an arbiter on that board, it doesn't matter because they already ruled how it was, and that there's nothing I can do, and my hands are tied, and that you have to pay the $5 million, Mike Lindell. Well, 1 year ago, Lindell appealed this decision to a 3-judge panel of the United States Court of Appeals for the Eighth Circuit. In July, the panel issued its ruling overturning the federal court's decision and the arbitration decision. Their order was essentially based on the fact that the arbitration agreement that Lindell had me sign at the Cyber Symposium stated that to win his $5 million challenge, I must, quote, prove that the data Lindell provides unequivocally does not reflect information related to the November 2020 election, end quote. Lindell's lawyers claimed that I had only proven that the data was not a particular kind of data, electronic data known as packet data, which demonstrates something was sent along a network, usually the internet, but that I had not proven that it was any kind of data related to the election. Lindell's false claim was that the election vote tallies, which are not supposed to be connected to the internet so as not to be hacked, were in fact being sent all over the internet. There's important precedent that explains why Lindell should not have prevailed. The Supreme Court made it crystal clear in Oxford Health Plans LLC v. Sutter that an attempt to vacate an arbitration decision because the losing party disagrees with the interpretation of the contract is, quote, not properly addressed to the court. This is exactly what happened in this case. Yeah, so he's arguing, they're arguing basically that it is not the federal court's job to arbiter whether the arbitration court did their job, right? Basically, they're saying you guys agreed to it. You guys both signed a contract saying you would go to an arbitration court to handle this dispute, okay? And that whatever agreement, whatever ruling the arbitration court gives is the binding ruling that you have to go with, okay? That has been the precedent. That's how this works legally. But that the circuit court, that the Eighth Circuit Court of Appeals basically disregarded all of that precedent and how it's supposed to work, and said, yeah, you know what, we're just gonna throw out the not only throw out like the lower court's ruling that like the arbitration agreement has to stand, but we're gonna throw out the arbitration court's ruling because ? In his brief to the appeals court, Lindell simply restated the same arguments he made in our original arbitration hearing and his appeal before Judge Thunheim without providing any new evidence that the arbitration panel might have overlooked. Lindell simply didn't like the arbitration outcome. Digging further, Lindell's brief to the circuit court claims that I didn't do a full or correct analysis of the data that he presented at his symposium. However, I submitted a report to the contest judges that explained that I used a well-known tool to examine Lindell's data and found that the data contained no packets in any standard format, which clearly demonstrated that it wasn't what he claimed. In any case, Lindell's own experts during 4 days of arbitration could not show any packet data or any other kind of legitimate election data to dispute my findings. When pressed about the data at the arbitration, Lindell's fact witness, Todd Sanders, claimed that the packet data had been transformed into a spreadsheet that had also been given to the cyber experts at the symposium. I explained in my report that the spreadsheet did not contain packet data or any other kind of data related to the 2020 election. The fact that the spreadsheet contained information that could not have possibly come from the packets was confirmed by Sanders when he acknowledged at arbitration that some unknown person had manually added most, if not all, of the information in the spreadsheet. This was further confirmed at the arbitration by Lindell's own expert witness, Doug Gold, who, in a Perry Mason-like moment of grilling by my attorney, Brian Glasser, admitted it wasn't possible for the data to have originated from or been transmitted to a voting machine. That seems to that's what the whole arbitration case is about, right? So, yeah, they say in a Perry Mason-like moment, basically their lawyer literally admitted, okay, yeah, this case is nonsense and that we know we're wrong. In fact, I testified at the arbitration that I had used all of the tools at my disposal, including off-the-shelf tools and tools I developed over 2 decades as a software forensic scientist to examine the data for any kind of relationship to the 2020 election. I found none. Since Lindell, his fact witnesses, and his expert witness all claimed that Lindell's data contained packet data, a specific kind of electronic data transferred along networks like the internet, the arbitrators focused on that particular issue throughout their decision. In fact, Lindell's own brief to the appeals court explicitly stated this claim. And yet, despite admitting that everyone on Lindell's team said the key to the analysis was packet data, before arbitration, after arbitration, and most importantly, at arbitration while testifying under oath, which I proved wasn't contained in the data and with which Lindell's own expert witness concurred, Lindell argued in his appeals brief that the arbitration panel incorrectly, quote, relied on statements made by Mr. Lindell and a Lindell expert witness, Dr. Douglas Frank, to conclude that if the data is not PCAP data, it is not from the election and it therefore cannot be, quote, related to the November 2020 election, end quote. That's funny. Lindell argued in his appeals brief that the arbitration panel incorrectly, quote, relied on statements made by Mr. Lindell and a Lindell expert witness, Dr. Douglas Frank, to conclude that if the data is not PCAP data, it is not from the election. So basically, he's arguing that, like, what is he arguing, right? Because it sounds like in the arbitration case, part of the evidence they used is the statements and claims that Mr. Lindell and his own lawyers made at the arbitration case, right? That basically they made weird contradicting incorrect statements about the packet data, and that they basically had to admit, yeah, there's no way that this could be connected to the November 2020 election. And so so basically Lindell is saying like, well, they relied on statements by me and my expert witnesses to prove this. But like, I don't how is that? That's not a legal argument, right? That doesn't mean anything. Lindell also objected to how the arbiters interpreted the contest rules, arguing that the standard should have been having to prove that there was no connection whatsoever between the data and the 2020 presidential election, no matter how far removed. As the arbiters made clear, such an understanding of the contest rules would make the contest unwinnable because Lindell's own proclamations that some random data was related to the election would, under such a ridiculous interpretation, cause any such random data to be ipso facto related to the election. They stated this in their decision. Quote, defining data as being merely about the election or relating to the election ignores contest rules reference to data from the election and reference to election data. These terms require that the data not merely be about the election, but must be from the election process itself. In fact, it would be unreasonable to conclude that the data about the election is election data. Newspaper articles and broadcast news about the election are transmitted as data over the internet, for example. It is unreasonable to conclude that any data file containing those accounts or excerpts from such a file would qualify as election data in a contest. If such data qualified, the contest would not really be a contest at all. Ultimately, the circuit panel's ruling is a disappointing decision and one that my lawyers and I believe is incorrect, not just factually, but based on all legal precedent. There are only rare cases where a binding arbitration decision has been overturned. Those cases typically involve some egregious error, such as illegal activity, bribing of the arbiters, unethical behavior such as obvious bias by the arbiters, or a ruling that is contrary to the law under any reasonable interpretation. None of these things happened here. My lawyers and I have decided to appeal the decision to the Supreme Court. My effort to overturn this decision is not about the money. This case is about our country and its principles. First, I believe that most Americans want voting to be fair and dependable. We also want any foreign government, large corporation, political organization, wealthy individual, extremist activist, or misguided hacker interfering with our voting systems by any means. But when a fanatic like Mike Lindell spreads lies about our voting system, we all waste resources and tie up our legal system, distracting us from the real voting issues. Second, the U.S. arbitration system is intended to allow a person of modest means to get quicker decisions at lower costs than having to deal with the long, expensive, labyrinthian legal system. I know this from experience because I've been waiting 4 years at great expense to get a final decision in this case, and now the wait gets even longer. We can't let wealthy plutocrats twist the legal system in this way. If this decision stands, it will be a devastating blow to arbitration in America because it means any binding arbitration decision can be brought to court and litigated at great length and with potential success. Arbitration outcomes will become a war of attrition, with the wealthier party having the resources to wait out a possible victory rather than taking the clear loss. This is not the system as it is designed, nor is it the system we should want. What I can't help but think of about all of this, right? I'm assuming that the Eighth Circuit Court of Appeals is I think I've heard talked about them in the past and that they are super, super conservative, right? That they have a number of direct Trump appointees on that court, right? That 3 of the 8 or whatever of the panel is made up of Trump appointees. I'm not 100% sure, but my understanding is that circuit appeals court, the Eighth Circuit Court of Appeals, is a particularly conservative one. Now, when I think of a conservative judge, who do I think of? Well, I think of mostly older straight white guys. Okay, I guess it doesn't really matter if they're straight white guys. They're just older people over the age of 40 or 50. Well, what do I think of when I think of people over the age of 40, conservative people over the age of 40 or 50? I think of Fox News. Okay. Well, what do I know about Mike Lindell and Fox News? Well, Fox News has treated Mike Lindell extremely well. They bring him on all the time as like some sort of subject matter expert regarding election fraud, and he makes all sorts of wild, crazy, very strong claims about the election fraud and all that stuff, voting systems dominion, blah blah blah, all that stuff. But as far as I understand, doesn't have any actual evidence or real backing behind any of this, right? I guess the point of all of this is my understanding is that he's sort of a sweetheart child. He's sort of a golden child of the rights media right now, right? Especially amongst the older crowd. They see him as some sort of weird authority figure, even though he has zero authority whatsoever other than he knows how to smoke crack really well. And so I just can't help but feel like, I wonder, maybe the Eighth Circuit Court of Appeals justices watch a lot of Fox News, and maybe they just have a really weirdly positive view of Mike Lindell and are just willing to rule in his favor on this regard, even though it makes no sense and that there's no precedent for it. And as they pointed out, the examples in the past of these types of courts overruling arbitration agreements like this are in extremely egregious situations and circumstances and examples of which this certainly does not apply. So I just can't help but feel like this is some weird, like, pseudo right-wing media favorability towards Mike Lindell because Fox News. I'm getting real speculative here, but these are the things I think of when I think, old conservative justice, Fox News, Mike Lindell, election fraud. He probably likes him, I don't know. It's pretty stupid, pretty crazy. And also, there's nobody of all the people I can think of being forced to pay $5 million because they tried to create some sort of proving the election fraud wrong type of competition, right? It's Mike Lindell, right? He's the funniest person possible to have this happen to.